Hi, this is Patrick Conroy, and we're on Chapter 12, Issues in Electronic Discovery. Now, if you're in Technology in the Law Office, we covered this in there as well, probably a little bit more extensively than the other class. Learning Objective 1, define electronic discovery and explain how technology has changed the discovery process. Okay, computer usage in the law office has created a number of changes in the practice of law and litigation, as it has everywhere. Electronic copies have replaced hard copies, and the procedures, policy, and methods have changed, as they have everywhere. And courts have had to face the issue of electronic discovery. E-discovery refers to the discovery of documents created, disseminated, and stored via electronic means. So it could be files, on a computer that are documents, or it could be spreadsheets, or it could be databases, it could be PDF files. And the court has rules that govern issues such as preserving electronic materials, how long they have to be saved, producing electronic materials to the other side, and destroying electronic materials. How long do they have to keep electronic files before they can get rid of them? And that's any company. Ethical issues in document discovery. The legal team has a duty to protect the documents and satisfy discovery requests in compliance with court discovery orders. Removing or changing metadata can lead to the court-ordered sanctions. Now, if you've taken legal ethics, when they say ethical issue in law, in the practice of law, that's actually a rule. It's not just, something that's good to do as a person. So the legal team has a duty to protect the documents and satisfy discovery requests. And removing in metadata is, we'll be showing you an example of metadata in a couple of slides. So, preserving electronic materials. Once a client has a reasonable belief that litigation may arise from a particular dispute, there's a duty to preserve all documents related to that dispute. Once a client has a reasonable belief that litigation may arise from a dispute, a duty to preserve all documents related to that dispute also arises. Well, that's a poorly written sentence. What that means is, hey, even if there hasn't been anything filed with the court, or there's no complaint issued, but the client has a reasonable belief that litigation may arise. Someone has said, hey, I'm going to sue you, or that they've been having trouble with the client, and they think that they might sue, that's when the duty arises. And the need for preservation may require placing a matter and all documents related to it on litigation hold. That's the term that lawyers will use to say, hey, you have to put a hold on all these, you can't destroy them. Now, most companies have to keep records for other reasons, for like 6 years or 10 years. But but this is to say you can't destroy any of these because we think we might need them in discovery, or they might be requested. Documents in litigation, they should be saved in their native format. If it was created in Word, it should be in Word. If it was created in Excel, it should be in Excel, not converted to a PDF. Okay, now when you have scanned documents to be scanned, that allows what's called OCP, an optional character recognition program, allows the conversion of paper documents into searchable electronic documents. So it's not just that it's enough that it's in electronic format. It has to be one that can be searched, because you will have mountains of documents to go through. And so you need to be able to do a search on key terms or phrases. Metadata. Okay, the next slide kind of shows it. data set that may describe, for example, how, when, and by whom it was received, created, accessed, and or modified, and how it is formatted. It's you don't usually see it in your email, but it is all there in an email. And if you created a Word document, over here on the right, you see under info, it says who created it, when was it last modified, and that might be pertinent, especially in a case where, like, somebody says, hey, I never knew this. Be like, hey, you created this document saying it. Production of documents created and stored electronically falls under the traditional production of documents discovery tools. So it doesn't matter whether it's paper or electronic, the same production of it's all discoverable. Spoliation. That's a term that's used when it's the destruction of evidence, when the party knows or should have known there is a pending litigation. Now, it's not deliberate necessarily. They're not going to make any judgment whether this was deliberate or accidental or, just happened. That's just the term, spoliation. But it is punishable by sanctions against the party who destroyed the evidence. Now, information technologists are often part of legal teams, or they might be, somebody you bring in as an expert. IT specialists can become valued members of the legal team because they understand the electronic format of the documentation and the efforts required in producing or reproducing it, and the latest developments in the field. Basically, they can help you go through all of the database and find records, go through all the electronic formats. Sometimes you might need to, the law office will have somebody on staff, or they could just, outsource it. Okay, this is a letter to a client saying, hey, preserve stuff. And it's from the general counsel, and it says you might have stored information. You're going to have to save it in case it's requested. Okay, we'll stop there for this part and pick up with part 2 in the next presentation.